Next up is Kubo Macak. He's working as a law professor at the University of Exeter. And he has produced a paper that is also going to be published at the proceedings of this conference. So, Kubo, the floor is yours.
Thank you, Mari. So, is the international law of cybersecurity in crisis? Is this glass half empty? And the answer to both questions depends on whether you see yourself more as an optimist or as a pessimist. And so today I'm going to try to give the optimist's take on the current situation. And I'm going to argue that we should view the situation as a prime opportunity for the states to reclaim their central role in international lawmaking. So, although there are ongoing debates about the extent of the decline of the sovereign state among international lawyers, the fact remains that any analysis of international lawmaking, interpretation, and application must start and finish with states. And so I'm going to do exactly the same thing in my presentation, as you can see in this visualization. So I would argue that this approach applies to cyberspace as well. And probably this audience needs no reminder that cyberspace as a borderless space, the uses and abuses of which impinge on vital state interests, which include national security, economic development, and public safety, extends well beyond the domain of internal affairs. So what we need to understand is how international law applies to cyberspace. Now, unfortunately, for a long period of time, the reaction of states could be likened to a metaphor of a sleepwalker. So if you think about sleepwalking, you start with these dreamlike fantasies, the slumber might be taking a little bit too long, maybe you are moving, but you're not really sure about the direction in which you're moving, and probably at any given time, the best idea would just be to wake up. And so I would argue that to some extent this metaphor applies also to the reaction of states to this area. So we have had these early fantasies of cyberspace as a terra nullius, if you will, a sovereignty-free space. And then it took some time for the slow awakening, quicker among some states and slower among others, that the applicability of international law extends to cyberspace. So finally today, as Mike has said, we know that international law applies, but we don't always know how it applies. And then, does this mean, if we don't know that, does this mean that we are in the midst of a crisis? Well, there certainly are some indicators of a crisis. So first of all, the area of cybersecurity appears to be resistant to codification. But this is not for the want of trying. Already in the 90s, in 1996, we had the French Charter for International Cooperation on the Internet being proposed. And in 2011 and 2015, the better-known codes of conduct for information security proposed by Russia and China. But all of these have been met with little enthusiasm by other states. Secondly, of the two components of custom, state practice and Opinio Juris, both are quite problematic. The state practice in this area, as Mike has said, is inevitably shrouded in secrecy. And then secondly, statements of Opinio Juris for now are few and far between. And then thirdly, what is interesting is that states have not entirely resigned on cyber governance, but instead of developing and interpreting international law rules, they have sought refuge in the vacuous language of norms. So overall, what we see is this normative activity outside of traditional international law. Certainly, this is not limited to cyber. When we think about international law, this has been described as a process or a general trend of pluralization of international norm making. But what impact do these factors, or the combination of these factors, have on cyber governance? Well, it's certainly not true that we wouldn't have any rules that would apply in this area. We have the existing generally applicable rules of international law, which apply also to conduct in cyberspace. And we may refer to the logic of the International Court of Justice's advisory opinion in the nuclear weapons case, where it was faced with the question, so if nuclear weapons or the knowledge of the invention of the nuclear weapons became public only after the UN Charter was adopted, does that mean that the provisions on the use of force found in the Charter do not extend to nuclear weapons? But the ICJ gave short shrift to this argument and argued that the provisions on the use of force apply to all and any weapons insofar as they amount to use of force between states. And so the same logic should apply to cybersecurity. So certainly generally applicable rules apply to cyberspace as well. And then we have what has been described in the literature as a patchwork of regulations. In other words, some sectoral and regional treaties, the aspects of which cover aspects of cybersecurity. But the problem with these treaties is that they are either too narrow. So let's take the constitution of the ITU. Yes, it deals with operations that would interfere with telecommunications networks. Or let's take the Budapest Cybercrime Convention. Yes, it deals with offenses that are conducted by computer means. But they only cover a very narrow sliver of types of operations that we come in contact with. Or if they aim to be more comprehensive, their take-up in the international community is very slim. So we have the Shanghai Cooperation Organization's Information Security Agreement, 6 member states, and the African Union's Convention on Cybersecurity, 0 ratifications as of now. So all in all, and thirdly, what we see is despite these generally applicable rules and the patchwork of regulations, we have an absence of a complex regulatory mechanism in this area, which has generated an overall power vacuum in the area of cybersecurity. So looking at this power vacuum 2.0, if you will, and looking at the interaction of law and power, I will admit that these vectors, the vectors of law and power, do not overlap perfectly. There are certainly other factors that impact on state power, such as military might, economic wealth. The idealists among us believe that even moral authority has some claim to fame. But still, law plays an important role. So there are 2 archetypal approaches that we may think of in this connection. Firstly, law may be used to generate legal certainty. And by generating legal certainty, states use it as a tool of consolidating and projecting their power. The second archetypal approach, and quite the opposite to the first one, is to use the law as a means of maintaining legal uncertainty. So as a means of maintaining, in the turn of phrase of, if I'm not mistaken, Henry Kissinger, maintenance of constructive ambiguity to protect existing power. And if that sounds a little bit too abstract, then let's consider the law of outer space. And especially in its early phases, there were only 2 states that were capable of space activities, the United States and the then Soviet Union. And both had resisted for more than a decade to the development of any binding rules, under the belief that any such rules would only amount to a constraint of their activities in outer space. So, but before you conclude that cyberspace is somehow similar, let me argue that it is actually decidedly different when it comes to the approach between the law and power. So, it is decidedly different because in cyberspace we have a multiplicity of actors. We don't just have 2 states, but we have basically all the states acting in cyberspace. But in addition to that, and very importantly, we have a plethora of non-state actors, including all of you, those of you now on Facebook or Twitter, including corporations and including various loosely organized groups of individuals. If we come to think of, anonymous honker group, Cyberberkut, name your own favorite, cyber group. And so the effect of legal uncertainty, because of this situation, because of the multiplicity of actors, and because many of them are non-state actors who may then benefit from this problem of attribution, or its flip side, the problem of anonymity of operations in cyberspace, because of that, the effect of legal uncertainty is much more complex. And so thus, the withdrawal of states from this area has generated a power vacuum. But as we know, nature abhors vacuum. And so the withdrawal of states has meant that non-state actors have moved into this vacated territory. I would like to highlight 2 of such initiatives. Mari mentioned others, and to this audience, they will probably be very well known. So I'm not going to focus on the details of these initiatives. I will say, looking at the Microsoft's initiative of the December 2014, and of course the Tallinn Manual, of which we have the chairman of the group of experts among us, there are some important differences between these initiatives. They differ in who led the process. The first is an industry-led process, the second is a primarily academic endeavor. They differ in their pronounced aims, and they also differ in the specificity of the norms or rules that they propose. But they have some important shared features. They are expressly non-binding in their approach. They have a decidedly non-state origin, but despite of these 2 aspects, they are state-centered or state-oriented. So what they do is they propose a normative framework to be observed not by non-state actors, but to be observed by states in relation to their cyber activities. So perhaps you're asking yourselves, well, if they are non-state activities, and if we have to start and finish with the states, then what is their relevance from the perspective of international law? And my argument is that the relevance is that such initiatives amount to norm-making laboratories. So yes, I admit that the normativity in the sense of the strength of their claim to authority is much lower than that of international legal rules. But that does not mean that they are without relevance for international law. So firstly, such initiatives may constitute an intermediate stage towards a more rigorously binding system. Secondly, these initiatives increase the inclusivity of the norm-making process, and they do that simply by including the non-state actors in the participation and in the process of norm-making in international law. And then thirdly, their eventual destiny, of course, will depend on the reaction of the states. And this is why we are now at a critical juncture. We are now at the moment when we will see whether states lift this gauntlet thrown at them by various non-state initiatives or not. And so in my research, and you can see that in the paper that was referred to you, I analyzed various historical parallels in other domains, and these have included the law of Antarctica, also my chance to include a picture of penguins in my presentation, the law of nuclear safety, and I would argue that similarly to these two domains, there have been other areas, like these two, that have resisted for some time the development of binding global governance structures. And so they resorted, sometimes for decades, to non-binding rules, to non-binding norms before complex binding instruments could have been adopted. So today, I would argue, we are starting to see some early signs of convergence between the various non-binding initiatives that we observe also in the law of cybersecurity. So what happens next is the crucial question. And so all in all, on the basis of this argument, I would argue that this amounts to a moderately optimistic picture. In other words, it's a glass half full, if you will. So I think my conclusions can be summarized in 3 steps. So firstly, in the absence of state-led lawmaking, these non-state initiatives that we see should not be seen as signs of crisis, but rather they should be seen as an opportunity. They should be seen as an opportunity for states to identify the overlaps between these various initiatives and their strategic interests. Secondly, it is the right time to do that now. And I would argue that the advances that have been made in relation to the attribution problem show that time may be ripe today for states to endorse the regulatory and deterrent potential for international law rules. And so thirdly, on this basis, states should reclaim their central role, or let me say that again, states should reclaim their central role in international lawmaking. And this central role amounts to these 3 steps: short-term, medium-term, and the long-term one. So in the most immediate term, states should become more forthcoming in expressing their cyber opinio juris. By doing that, they will allow all of us to be able to consolidate cyber custom and better understand what rules actually apply in this area. In a more medium term, states should overcome their current aversion to treaty commitments. And we are seeing some early signs of hope in various bilateral developments between various cyber superpowers, but also potentially lesser powers in this area. And then finally, in the perhaps most long term, all of this could amount to an agreement on a comprehensive multilateral undertaking on cybersecurity. With that, I would like to thank you for your attention, and I look forward to discussing this more during the questions. Thank you.
Kubo, I have a lazy toolkit for you also.
Well, thank you very much.
Thank you.
Well, my adoptive country now is England, and gardening is very popular there, so I should probably take up this national sport. So this is a good occasion. Thank you very much.
Definitely. Thank you very much for your insights, Kubo, and propositions for the way forward.